Good afternoon and welcome to the Hudson Institute. My name is Urška Petrovčič and I'm a senior fellow at the Hudson Institute. Today's event is hosted by the Forum for Intellectual Property, a center at the Hudson Institute that promotes evidence-based discussion on IP rights. The webinar will focus on standardization and patent policy, and more specifically on the business review letter, the so-called BRL, that the Antitrust Division of the US Department of Justice issued to the IEEE, one of the world's largest standard development organizations. We have a special guest today that will be moderating our event. We have the honor to have with us Dr. Walter Copan, former Undersecretary of Commerce for Standards and Technology and the 16th Director of the National Institute of Standards and Technology, NIST. He's currently a senior advisor and co-founder of the Renewing American Innovation Project at the Center for Strategic and International Studies in Washington, D.C. Director Copan, thank you for being here. And please, the floor is yours.
Urška, thank you so much, and thank you to the Hudson Institute for hosting this very important program on standards, on intellectual property commerce and licensing, and its connections with competition and antitrust policy. I'm Walter Copan, and a very warm welcome to all of you. Technical standards play such an important role to open the doorway to technology acceptance and adoption around the world. Standards that help ensure product performance, quality, safety, and interoperability. Standards development organizations, or SDOs, convene technology experts representing public and private sector organizations and interests, together with governments, and they operate with rules that must be seen as transparent and fair. Standardization is a process where competitors need to come together to form a sort of consensus and to document the technical performance requirements of products and systems. Whenever competitors are in the same room, of course, there are concerns about maintaining fair competition and abiding by antitrust rules, which must be addressed. And so technology developers, innovators, and implementers represent the key players in ecosystems of intellectual property transactions, and standards essential patent holders make commitments through their SDOs to license these intellectual property rights on terms that are fair, reasonable, and non-discriminatory. So there are often complex global negotiations that involve many inventions, and the transactions include cross-licenses where each party brings a series of intellectual property rights to the deal. We've had some important elements in competition law and antitrust policy that is subject of our expert panel today. So to help us illuminate these topics, I'm delighted to welcome three distinguished experts, Richard Taffet, Elisabeth Opie, and Georgios Effraimidis. Richard Taffet is with the Morgan Lewis law firm with extensive experience in competition law, intellectual property and technology standards, and licensing matters around the world. He has dealt with matters of policy with standards development organizations globally, and also in litigation and all matters of the courts at all levels, including up to the US Supreme Court. Elisabeth Opie joins us today from the law offices she opened in Munich in 2014, where she is principal solicitor. Her work has specialized in dealing with international technology and innovation in various sectors, with practice areas in international law, international trade law, the commercialization of technology, competition, and dispute resolution. Georgios Effraimidis is Senior Manager of Economic Strategy at Qualcomm and brings a special focus on the high-tech industry and business development from the perspectives of economics, statistics, operational research, and quantitative analysis. He started his career in academia and has his Ph.D. from the University of Mannheim. So I'm now going to turn the floor over to Richard. And Richard, I'd like to ask you, would you please describe and begin at a high level what a business review letter is, a BRL, and why is it important? And would you please also share with us some insights into how BRLs developed and how they are ultimately used? Richard, over to you.
Thank you, Director, and thank you to the Hudson Institute for putting together this program and the opportunity to speak. And thank you for the question. A business review letter is a somewhat unique process or a vehicle by which private parties can obtain the views of the Department of Justice Antitrust Division regarding whether potential, proposed, prospective conduct violates the antitrust laws at the time when the DOJ is asked a specific question. A BRL is a vehicle that is provided for under the Code of Federal Regulation. It is not statutory and advisory by nature. And as I mentioned, it is purposefully intended to address only prospective conduct. So if conduct is occurring already, a BRL is not an appropriate step. The DOJ, the Antitrust Division specifically, is constrained in what it is permitted to do under the Code of Federal Regulation once it receives a request for a business review letter. It can either state its present intention with respect to conduct as of the date of the request, and I'll get more into that process in a moment. It could decline to pass on the request at all, or it could take such other actions as it considers appropriate. So to give some context to this process, it may be useful to understand how a request is formulated and the DOJ considers these requests. Any private party who is looking for guidance can put together a request for a business review letter. Typically, one would set forth a specific conduct for which the organization or entity or person has some concern or wishes some guidance. The DOJ will take whatever facts are given to it, and only those facts, except for the possibility that the DOJ will conduct its own unilateral investigation, because it can go and speak to, and typically does speak to, third parties as well to determine whether the conduct is likely to give rise to competitive issues and whether the DOJ will have any present intention to bring an enforcement action. After the review, and typically the DOJ attempts to complete the review in a matter of a few months. In the last couple of years, this has extended out for many months, in part because there's an increase in business review letter requests. But once it does, as I mentioned, it can the DOJ can offer take three paths. Typically, though, if it is clear that it will issue a positive business review letter, it will say it has no present intention to bring an enforcement action. Typically, if it is given an indication that it is reaching a negative view, a party can withdraw the request, and then it is confidential. It remains a confidential matter. Importantly, BRLs have no precedential effect in U.S. courts. There are very, very few cases which even cite to DOJ business review letters, oftentimes looking at them as informative but not controlling. And every BRL, I think, that has issued, as far as I know at least, and I've seen quite a number of them, expressly state that they are limited to the facts and the law at the time that the BRL issues. And if there are changes, the DOJ expressly reserves the right to change its position. So that's a basic overview of how the BRL works and what its effect is.
Richard, thank you so much. Georgios, would you like to add any comments or views on the BRL in response to the comments that Richard has just made?
No, I don't have any comment, and Richard is the expert, so he covered perfectly.
Wonderful, thanks so much. Elisabeth, I'd like to ask you next to respond to this question. The Department of Justice Antitrust Division issued a BRL, a business review letter, in 2015 on behalf of the Institute of Electrical and Electronics Engineers, IEEE, as Urška mentioned in her opening comments. So this is a professional organization, a standards development organization, highly respected. Would you please describe why this BRL was issued and what did it cover? What did that BRL state from the Department of Justice?
Certainly, and I'll say right up, I'm also very pleased to be part of this panel and perhaps can provide a slight European perspective in answering your question as well. I'll provide some factual background and then make some comments through the lens of sustainable innovation and international trade. Ultimately, these are the objectives for the benefit of society through the use of globally competitive international technical standards. So we'll go back to the 30th September 2014. This is when the IEEE requested a business review letter regarding proposed changes to its patent policy. And two particular features that it was seeking clearance for was for the introduction of a two-step court process as a condition precedent to seeking a prohibitive order preventing infringement of standard essential patents, so on injunctive relief, and a limitation on negotiations insofar as these relate to license fees. The interesting aspect of this request is that the proposed changes would introduce essentially a commercial term sheet into the patent policy, which affects the rights and obligations of all parties to the RAND negotiation, as you said, reasonable and non-discriminatory. There are a number of assumptions which form the basis of the IEEE's substantive changes to its policy. Part 3 of its application states that the IEEE seeks to produce standards that any willing implementer can use. And the assumption here appears to be that no implementer would engage in patent holdout. The application then goes on to portray patent holders as demanding grossly excessive license fees and holding the sword of Damocles in the form of injunctive relief over the head of patent users in order to finalise license negotiations. So on the 2nd of February 2015, the Acting Assistant Attorney General of the Department of Justice Antitrust Division issued what we now know as the IEEE BRL. And this BRL added perhaps a gratuitous observation that the proposed changes would benefit competition by mitigating against patent holdup and royalty stacking. The BRL appears to be based on a portion of a whole economic theory. We always hear about patent holdup, patent holder, royalty stacking. However, since 2014, I've observed in the US, courts have clearly confirmed that there is no presumption at law that any of these exist. Every set of circumstances must be assessed on its own merit. And if a failed negotiation should make its way to court, then the alleger of certain circumstances must plead these, the alleged egregious conduct, and bring forward cogent evidence to prove the allegations. Looking at this through the lens of Europe, so the European Court of Justice, of the Court of Justice, I beg your pardon, of the European Union in Huawei against ZTE, affirmed that both parties to a FRAND or a RAND negotiation have a positive duty to enter into good faith negotiations regarding the use of standard essential patents. All parties have rights and obligations in this regard, and both must place sufficient information before the other so that an arm's length negotiation can take place. The underlying assumptions of the IEEE business review letter, as well as the application itself, did not take that into account, it would seem, from my perspective. If we take it to an international trade perspective, and looking at the two-step process to actually obtain injunctive relief, this could be categorised as a non-tariff barrier to trade. And this was recently acknowledged by the United States Trade Representative Office in its 2021 National Trade Estimate Report. It, in that report, identifies foreign barriers to US export of goods and services, investment and digital trade by classifying them into 11 categories. One of them is identified as inadequate enforcement of intellectual property rights. So injunctive relief being an aspect of that. More recently, the World Trade Organization has released its first report on the economic impact on non-tariff barriers to trade. This was in its report on the Trade Cost Index. And one of the main findings set out in the WTO Trade Cost Index is that trade policy barriers and regulatory differences are estimated to account for at least 14% of trade costs in all sectors. They include tariff and non-tariff barriers, regulatory differences, as well as other policies covered by trade agreements, such as a lack of investment facilitation or of intellectual property protection. So injunctive relief is a remedy granted, and if not, there's no ability to apply for such a remedy, it actually makes it almost impossible to efficiently or at all enforce rights. I will turn quickly to the license fee aspect. An element of this BRL was to seek to have the smallest saleable patent practicing unit really taken into account as part of the cost negotiation. And if we look at this through an innovation lens, taking this perspective, I've noted as well, the US courts have said that such a position is untenable to always be adopting. But from an innovation perspective, there needs to be a return on investment. Otherwise, there is no incentive to contribute to the work on the development of international standards. And I guess from a competition law perspective or antitrust perspective, return on investment is seen as a key to actually encourage innovation. We see that in the joint FTC, DOJ joint licensing guidelines for intellectual property. This is also reflected in Europe in the horizontal guidelines. So a little bit of a précis from my part, beyond just describing what the BRL actually sought and what was obtained. But hopefully that's useful for the rest of our discussion.
Wonderful. Thanks for those insights, Elisabeth. Let's turn it over now to Georgios in answering the following question. In 2020, the Department of Justice Antitrust Division took an unusual step, and it issued its own update to the BRL for IEEE. This was clearly seen as an important priority for the Antitrust Division at that time. Would you please describe, to the extent that you can, the reasoning behind the update and what it was intended to accomplish? Georgios?
Thank you, Walter. I would like to thank the organizers for the invite and giving me the opportunity to participate in this event with such great speakers. And I would also like to make the usual disclaimer: any opinions, views I express today are mine and do not necessarily reflect the official position of Qualcomm. As you said, in September 2020, the Antitrust Division of the Department of Justice issued a letter which intended to update, supplement, and append the 2015 BRL to the IEEE. And most importantly, the agency said that it took the extraordinary step. So the agency itself used that term, extraordinary step, of issuing the 2020 letter because it had become aware that the 2015 BRL was mischaracterized, was misquoted internationally as well as domestically. And indeed, since March 2015, there have been a couple of instances where the BRL, the 2015 BRL, was misquoted to support contentious propositions regarding various parameters of the front commitment. For example, we've seen foreign antitrust agencies to use the 2015 BRL as a weapon to favor national champions. We have also seen companies or private interest groups to misquote the 2015 BRL to support their arguments. For example, Apple, in submission to the European Commission, cited the 2015 BRL in order to support its argument that licensing at device level is a violation of the front commitment. Similarly, the ACT App Association, which represents app makers and connected device companies, made a similar argument in a submission, in a brief submitted to the US Court of Appeals for the Ninth Circuit. So, and besides, in addition to the issue of mischaracterization, DOJ gave two other reasons for the 2020 update. And first, it stated that rather than providing clarity and certainty as the initial BRL, the 2015 BRL had predicted, in the new patent policy, which became effective in 2015, may in fact be discouraging participation in the IEEE, and also possibly that chilling innovation. And regarding this, my two co-authors, Kirti Gupta and Urška Petrovčič, and I recently published a paper, and what we did is to perform an empirical analysis, and our findings actually show that DOJ's concerns were valid and justified. And in fact, the new patent policy, which became effective in 2015, did not provide any clarity or extra certainty. And if any impact, in fact, evidence suggests that the new patent policy had the opposite effect, namely less clarity, less certainty. And the other reason that DOJ stated for issuing the 2020 update was that the analysis in the 2015 BRL was outdated, and therefore the DOJ stated that they knew this update, one goal, objective of that update was to align that outdated analysis with the current US law and policy, which has evolved over the last 5 years with respect to licensing of standard essential patents and governance in standard development organizations. And regarding this issue, perhaps the Richard or Elisabeth can speak more in detail about that, given that they are great lawyers and they have extensive background in this area.
Excellent, Georgios. Thanks so much for those insights. And I'm going to turn it over next to Richard to respond to any comments that Georgios has just made. And also in April of 2021, Acting Attorney General for the Department of Justice Antitrust Division took action to reclassify the 2020 BRL for IEEE as a competition advocacy document and moved it to that portion of the Department of Justice website. So Richard, in addition to any comments you'd like to make in response to Georgios's views, what are the implications of the change from the DOJ, and what is its legal effect, if any?
Thank you. And let me first begin by perhaps offering some context, historical context for the BRL, which I think will put in place Georgios' comments and Elisabeth's comments of what the BRL actually contained. So I think it's important to note that at the time the IEEE adopted its patent policy in 2015, and it was anticipating to do so contingent upon receipt of a positive BRL. The dialogue in IEEE had been going on for over 2 years. And the issues, to say the least, were contentious. There were process issues that were raised that the BRL recognized but did not consider to be significant. And this goes to the typical consensus process, as Walt, you identified in the standards development process. And what emerged from the IEEE's process was a policy that reflected positions, as Elisabeth very correctly and cogently identified, that had been advocated in different standards bodies throughout the world for many years without success, because they had not been recognized as having consensus support. The as I say, the BRL then created, I think, this natural experiment that Georgios reflected and was able to, some years hence, be able to identify empirically whether, and from an antitrust perspective, I think most importantly, the rationale, the competitive rationale for the conclusion that the IEEE's new policy in 2015 would not have anti-competitive impacts was that it would provide, to the contrary, pro-competitive outcomes of greater certainty. And I think, and I would commend the paper that Georgios mentions that he and Urška and Kurti Gupta put together. I commend that, and it's an extraordinary piece, and it's very well put together. But what the natural experiment showed is that indeed there was a distortion of the competitive process, leading to less clarity, perhaps, but from an antitrust perspective, less output, meaning that there was not as free-flowing licensing. And the point here, and this is getting to your ultimate question of the conduct or the step taken by Acting Attorney General Powers this past April, is what is going on, and there is perhaps a policy disputes that are being reflected and played out through the DOJ. As Georgios mentions, the 2020 update was extraordinary in DOJ's own words. And I could only speculate why a step has been taken in April to reclassify the 2020 update. There have been some reasons given that it's purely administrative. As I think Georgios's paper and my research has shown also, that this is the first time that the extraordinary step of updating a BRL has been taken. There is no process, as I mentioned, in the Code of Federal Regulation for eliminating a BRL. Whether it's still in effect will depend on the state of the law and the state of the facts if they've changed. So there's a question that perhaps it is just as indicated, an administrative step. There is some question, though, also, why is it being taken now? We have not yet had even a nominated, much less confirmed, Assistant Attorney General for Antitrust at this point. And as we know, during the interregnums between administrations, the acting AAG is typically the head of the criminal division, which is not one that implicates the kind of issues that we are dealing with right now. So I think it will be interesting. I understand that the antitrust division is formulating positions and will be speaking to such organizations as ANSI in the near future about how it is viewing issues of IPR, the interface of IPR and antitrust. So I think we really have to stay tuned right now and see how these develop. But I will say that what's been very interesting, including the time when you served as director of NIST, is that there was a significant movement towards a greater understanding and recognition of what had been a long time understanding of the complementary nature of IPR and antitrust. And this goes back to Supreme Court cases in the Simpson Oil case in the 1960s, where the two laws are in mutual, and neither takes prominence because they both have the same goal of advancing consumer welfare and competition. So I think we're in a very interesting state right now from a practical standpoint. I would like not to hazard speculation, well, more than I have, I guess, already. So maybe that's a helpful way to conclude this comment.
Richard, thanks so much for those insights. And we're not wanting you to go on a limb here with too many speculations, but let's go back to the data and to the paper that was complemented in these remarks, paper Georgios, to which you were a co-author. And you developed an in-depth analysis of the impacts that came from the initial issuance of the 2015 BRL, and also the effects of the IEEE's patent policy revisions that were adopted after the issuance. So this involved an empirical analysis of the effects that the revisions had on the standardization process of IEEE. Would you please describe the findings of your study and its recommendations? Georgios.
Oh, definitely. Thank you, Walter. So let me give a bit of background. So as I said, DOJ in the 2020 update stated that rather than providing clarity, as the 2015 BRL had predicted, the new patent policy actually discouraged participation in standard developments in IEEE and possibly chilling innovation. And it also noted in the DOJ in the 2020 letter that the pro-competitive benefits of the new patent policy, as predicted by the 2015 BRL, did not materialize. And in relation to that discussion, the 2020 update made a reference to negative letters of assurance, LOAs, submitted to IEEE. And negative letters of assurances where the owner of a potential patent claim declines or is unable to make licenses available under the new IEEE policy. So what the DOJ said in the 2020 update that there was a significant increase in submitted negative LOAs between January 2016 and June 2019. And it also noted that because of this increase in negative LOAs, the National Standard Institutes declined to approve two proposed IEEE working groups. So in light of this discussion, what my two co-authors, Kirti Gupta and Urška Petrovčič, and I have done is to determine whether DOJ's arguments or justifications or arguments were justified. And what we did is to analyze how firms involved in the development of IEEE standards reacted to the revised patent policy in 2015 by looking at submissions of letters of assurance over time. And specifically what we did is to focus on the 802.11 working group, the working group which is responsible for the development of Wi-Fi based standards. And the reason we did that is that this working group produces the majority of SEP intensive standards in IEEE. Therefore, if we want to assess what the impact of the new patent policy was, then what we have to do is to look at this working group, which, as I said, is produces patent-intensive standards. So let me share my screen, and then so that I give you a high-level overview of the results of our analysis. Okay, so what we saw, as I said, the key takeaway is that after the new patent, the update of the patent policy, there was a significant increase in the number of negative letters of assurance after the policy change. So the graph on the left, what shows is that while there were virtually no negative LOAs before 2015. After 2015, we have a sharp increase. We observe a sharp increase in the number of negative LOAs. And in fact, in 2019, the number of negative LOAs, submitted negative LOAs, reached a historic high. 11 negative LOAs were submitted in 2019. And the graph on the right shows that there was also an increase in the percentage of negative LOAs submitted after the policy change. So what you see is that between March 2015 and November 2020, more than 30% of the submitted letters of assurance were negative, while the equivalent figure before the change of the patent policy was only 0.5%. Therefore, as I said, the main key takeaway here is that there is a significant increase in the number of negative LOAs. In other words, we observe a large number of patent owners to explicitly explicitly state that they are declined or are unable to make a license available under the new patent policy. Now, why this is important, and clearly the empirical findings contradict what the 2015 BRL said, that the new patent policy will add clarity and certainty into the licensing negotiation process. And why this is the case? Because what happens is that what we observe is that we had a number of Wi-Fi standards which were approved under a mixed bag of negative and positive LOAs, which clearly introduce uncertainty. Why? Because what happens is that for the same standard, we have SEPs which are subject to the new patent policy, and also SEPs which actually the licensees do not know whether those SEPs are subject to the old policy, to the new policy, or whether they will be licensed at all. Therefore, what we can say is that this patent, the change of the patent policy, actually increased uncertainty, and as a result, this increased inefficiencies in licensing negotiations and made less effective the implementation and commercialization of Wi-Fi based standards.
Georgios, thank you so much for those insights, and also for taking the detailed view that you and co-authors have provided in the analysis of the impact of the BRLs on licensing, commercialization, and indeed on the basis of innovation itself. Let's turn it over now to Elisabeth. Elisabeth, when the 2020 update was issued by the Department of Justice, it stated that the original BRL was being mischaracterized and incorrectly referenced by the IEEE and others as an endorsement or an approval of the group's patent policies. It goes on to take exception to the IEEE's policy constraints on patent owners, seeking injunctions in court to stop alleged infringement, and also its recommendations about how royalty rates should be set and negotiated. Would you please shed some additional light on this for us, Elisabeth?
Certainly. Excuse me. I briefly touched on these aspects earlier. I guess if we have a look at the ability to seek injunctive relief, the supplementary BRL noted that the denial of injunctive relief to essential patent holders could infringe upon the exclusive rights conferred by the US Constitution. And perhaps I would turn to Richard to elaborate more on that aspect. But certainly, you know, it also highlighted that the inability to seek injunctive relief was actually harmful to the incentive, so it reduced incentive for future innovation, and in essence allowed anyone to freely use the standard essential patents, knowing that at the most it will eventually have to pay at some point in time perhaps the reasonable royalty rate. And really, this is not how a sustainable innovation ecosystem can operate. The other aspect was on the use of the smaller sellable patent practicing unit, so SSPPU, as a royalty base. And the Department of Justice Antitrust Division considered that this is inconsistent with real-world licensing, particularly where the royalty attach point is on end product level, not at chipset level. And certainly it could lead to inefficiencies if one were to license at every level of the value chain, because not all the same license would be granted or need to be granted. The other was that to use this SSPPU method as a valuation mechanism or tool, it was actually never intended for that purpose. Rather, I understand, and again, Richard, I'll have to turn to you. My understanding is that it was used as guidance in jury trials in the US, not to as a legitimate way to always undertake the royalty calculation. The other aspect was, as I mentioned earlier, you've got patent hold-up, royalty stacking, which appeared to be underlying premises for the original application. So the supplementary business review letter highlights that patent holder was not taken into account. And to be honest, I can't recall if it was mentioned in the BRL, but I have been following the new body of case law that has been developing in the US on conduct and unwilling licensees, and have noted that there's a number of cases now where courts have granted treble damages, exemplary damages, where there have been unwilling licensees party to proceedings. Again, it's a case-by-case assessment, and in those particular circumstances, to fight essentially having a license put in place at every step of the way, demonstrated to the court that one of the parties was unwilling to engage in a good faith negotiation. So I'd say these were the main elements, and if Richard, you can expand further, perhaps the audience will appreciate that.
Yeah, Richard, let's turn it over to you to respond.
So there is a handful or more of interesting observations based on Georgios and Elisabeth's comments, and because I think they're in different positions. One is, let's start at first principles. What are we really talking about here in the IEEE patent policy, which is not unusual to have a patent policy in an SDO. Where it became unusual is really in two respects. One is to impose the types of restrictions that Elisabeth just reviewed, which at their core reduce the patent rights of a patent owner because the patent became a standard essential patent, an SEP. The second interesting aspect is that the IEEE put a context of antitrust onto this whole issue by going to the DOJ to get a BRL. But what has been emerging recently, and I think is clear from at least in the United States, and I believe in Europe as well, is that there's a growing consensus that the SDO IPR policies create a contractual relationship. And absent a clear evidentiary showing of anti-competitive effects, a breach of even a FRAN contract, even with deception, is not going to implicate antitrust law. The Ninth Circuit's decision in FTC v. Qualcomm just made that position clear. So what then becomes clear also, and this will amplify, I think, Elisabeth's points well, is that as a patent owner who contributes technology to the standards development process and clearly wants to or needs to invest a lot of risk capital into the invention and needs the incentives to contribute it to the standards process, that patent owner needs the incentives created by the opportunity to get an ROI, a return on that investment. But on the other hand, the industry to develop and implement the standards. But that's a contractual relationship. And yes, someone can forego their patent rights voluntarily, but where the IEEE stuck its finger and put it on the scale and created imbalance in what had been a global equilibrium of patent rights versus implementer rights, was to impose in these greater restrictions on patent holders. Yeah. And what is becoming clear there, and that involves all the cases now going forward, as Elisabeth indicated correctly, by the way, Elisabeth, you have a good understanding of US law. It's showing that these are not requirements, much less do they rise to the level of an antitrust violation. And I think Georgios comments in the findings in his paper of the misuse of the BRL, as I mentioned at the outset. The BRL has a very limited purpose, which is for the DOJ to identify whether it has a present enforcement intention at the time the request is made based upon the specific conduct. And it's not to have this broader context for which it was used, which I think is the 2020 update, I think was very helpful in putting those, setting that record straight. And also for international purposes, where I think there's a great implication. So let me stop there because I know you may have some follow-up questions.
Well, let me just follow up with that, Richard, and thanks for those indications about the benefits then of the updates that's supported by the data that Georgios and co-authors have indicated that are indeed pro-competitive. What is the subsequent change then to the status to competition advocacy document by the DOJ mean for the future? Do you have any insights for us on that?
Well, again, I think if there's some silver lining that we can find here is that the use and purpose of BRLs will now become clearer. Yeah. And so competition advocacy will move forward on a much better grounded basis, where there is always tension, I would say, globally between different regimes. And by that, I mean, countries, there are over 130 countries that have adopted antitrust statutes or regulations. And everybody in every country and jurisdiction is entitled to their views. But I think the important aspect that we may be seeing in the US, I hope, is a reversion to an empirically based, evidentiary based, effects based approach to antitrust law. And of course, this becomes much more complex when IPR is involved. Yeah. And it becomes even more complex when standardization and the use of patented technology and standards are involved. You can now see with the recharacterization of the 2020 update and the 2020 update itself as a continuum of just clarifying that, of course, the antitrust laws play a role, but of course we should not misuse pronouncements by the government, and the government has other advocacy tools through speeches and other actions, and of course litigation, and private party in the United States they always have the opportunity for litigation. But I think it's also important for the broader context of not just competition but competitiveness. And especially now in the areas for which the IEEE is involved, where the cellular mobile standards are being developed in what's the third generation partnership platform, 3GPP. There's another organization, 1M2M, which is really focused on machine learning and the Internet of Things. And hopefully we'll get past this advocacy. I hope the DOJ from the Antitrust Division, as we'll see as the leadership becomes more in place moving forward, recognizes the evolution of the understanding and the relationship of standards and antitrust and IP and antitrust, and maintains and allows for this equilibrium to resume, where it really is industry driving through consensus and through good governance, this balance that all interests can be maintained, because I defy anyone to dispute the absolute benefits of standardization that have occurred in the last 10 to 20 years. And I remember, and I apologize for digressing for a moment, but the first standardization in telecom in 1984, when AT&T was broken up, and all we talked about was POTS, plain old telephone service. And no one could ever imagine that there would be an internet or mobile or Wi-Fi or anything else. And to see in basically 20, 30 years, the technological advancements that have occurred and the benefits to consumers and social welfare is extraordinary, and antitrust should take that into context. So thank you for the opportunity to speechify perhaps a little bit, but I think it is important, not just for antitrust, but also for competitiveness globally, and for, which has national security issues, and how innovation can continue, which is, I think, an extraordinarily important issue for us to address. Thank you.
Richard, thanks for those insights. And indeed, these are exciting times where we've seen so much innovation globally that's enabled by standards and by the clarity of intellectual property rights to both innovators and implementers. So as we're coming now toward the close of our session, let me ask Georgios first, then Richard and Elisabeth to share with us what are the main takeaway messages from these developments between 2015 and today for standards development organizations and for the participants in FRAND negotiations for standards essential patents. Georgios.
Thank you, Walter. I think one key takeaway is that standard development organizations require collaboration among a variety of stakeholders. And to make sure that this collaboration is smooth, it's necessary that an SDO ensures there is appropriate balance among multiple competing interests. And unfortunately, with IEEE, the revision of the patent policy in 2015, what we noticed is that IEEE did not reach a necessary balance by giving insufficient weight to companies, to innovators that invest hundreds, billions of dollars in long-term R&D activities to create groundbreaking technologies which are used in smartphones, tablets, cars, and many IoT devices. And as we discussed, previously, the result of such an imbalanced approach in revising the patent policy and the revision of the patent policy was that actually we had less clarity, less certainty in the standardization process in the SEP licensing negotiation process. And so the lesson, I think the lesson we can learn from all those things is that any revision of an SDO's patent policy should be balanced. And why? Because such revisions have the potential to benefit or harm innovators as well as implementers of the standard. And we should always keep in mind that a patent policy must serve a two-folded function: enhance incentives of contributors to innovate, to contribute their technologies to the development of standards, while ensuring access to the new technology standards for implementers of the technology standards. So it is thus very important to prevent the use of the standard development framework for redistribution of the value created during the standardization process, redistribution between innovators and implementers of the technology. And as Walter, you previously explained, pointed out, standardization contributes to significant gains in terms of innovation, consumer welfare, markets become more competitive, And therefore, it is very important to adopt policies that do not compromise the credibility and performance of the standard development process.
Yeah. Georgios, thank you so much. Richard, what would you add?
That sums it up very well. One thing that I would add is to note that the IEEE has announced that it is reviewing the changes that it made in 2015. It's not clear exactly what that process is or what will occur. But again, I think it is important to see if industry in particular through consensus can develop a going forward position that establishes the benefits and balance that Georgios indicated, and that our antitrust enforcers do not put thumbs on scale, or other regulators do not put thumbs on scales. And I think that's incredibly important from the US perspective in the international and global marketplace. Yeah. Thank you.
Indeed, these are global challenges and implications. Elisabeth, let's turn it over to you for any takeaway messages you'd like to share.
Sure. I guess I look at it at the role of the government, the role of SDOs, and then what's happening in the market. And if policy at any level removes an incentive to contribute to SDOs, then this more probably than not will impact innovation cycles, particularly standards, and make them unsustainable unless there are government programs to fund further similar activity. Another observation in a greater context than just the DOJ observation is there's been joint statements released in December 2019. We had the joint statement from NIST, the USPTO, and the DOJ on the licensing of standard essential patents. The statements made in that were wholly consistent with the European perspective, particularly the framework as outlined in Huawei against ZTE, but also in the European horizontal guidelines. And this is hardly surprising given we're talking about international trade. They all have the same source. I think that it is important to have a whole of government approach, and the current US policy approach it appears in the main to be coherent and consistent, but when there's significant incoherency, that impacts on direct investment in the market. And we're talking about very valuable assets. So again, if there's uncertainty about something being protected, it will stifle innovation as well as the global trade aspect. Mm. I also observe that what's been stated is consistent with what's been stated in the courts in the US. So it seems to be affirming, vice versa, what has been said, as I said, by NIST, the Department of Justice, and the USPTO. Just two other quick points. I agree wholeheartedly with Richard. We need fact-based policy making, the use of empirical evidence. We've been looking at particular thorny issues that have arisen when looking at the licensing of standard essential patents. One thing that has to be noted is that there are many thousands, tens of thousands of licensing agreements that are concluded efficiently each year. And the business around standard essential patents seems to be thriving, particularly in the Internet of Things environment. The other final point I would say is the word balance. Balance has sometimes been used, let's weigh up your rights, let's weigh up my rights, and who deserves something a little bit more, some special favoritism. And I always define balance in this context as meaning each party arrives at the bargaining table with both its legal rights and its legal obligations intact. And that to me is balance. The law itself provides that. So thank you for allowing me those closing remarks.
Thank you so much, Elisabeth, and thank you to our panelists. Thank you, Georgios. Thank you, Richard, for your insights, for your comments on the importance of fact-based decision-making with regard to standards and intellectual property rights policies. We've seen the importance of standards development and the licensing process to global innovation and competitiveness. Thank you again to our panelists, as well as to the Hudson Institute for hosting this important conversation. Urška, let me turn it back to you to close.
Well, thank you, Director Copan. I think this was a fascinating event. We have addressed many important and very timely topics that are relevant in the United States, but as we have seen also in other jurisdictions. If I can briefly summarize the main takeaways of this event is that the BRL issued to the IEEE aimed to clarify the antitrust, that the antitrust division had no intention of bringing an antitrust action against the IEEE at the time, based on the planned policy revision. The letter, the BRL, has been subsequently misquoted, both internationally, and the 2020 update sought to end that. A few months ago, there were some reclassification of this update, but it's not clear if they have any legal implications at all. It certainly does not allow companies to misquote the BRL. But we have also seen that in addition to this policy discussion, empirical evidence have shown that if standard development organizations don't act by consensus, that can have some negative implications for that work. So to benefit from standardization, it's really important to find a balance between the various interests. So I think these are really important takeaways, and I think it has been a great event, and I would like to thank our moderator. I would like to thank the panelists for their inputs, and I look forward to seeing you again at the Hudson Institute. Thank you all.
Thank you.
It's been a pleasure. Take care, everyone.